One-call enforcement is one of the duties assigned by the Attorney General to the Environmental Law Division. We take this responsibility very seriously. When followed, the one-call law saves lives, prevents personal injuries, and protects essential utilities, property, and the environment. The law applies to anyone planning to engage in an excavation and to every owner or operator of an underground facility. The good news is almost everyone complies with the law. But for those who don't, the law authorizes the Attorney General to file suit in district court, where we ask the court to assess civil penalties and issue a court order prohibiting further violations. Here are the potential penalties. Violations involving natural gas or hazardous liquids pipelines may result in penalties of $10,000 per day up to a maximum of $500,000. Violations involving other underground facilities may result in penalties of $1,000 per day up to a maximum of $20,000. We have filed 52 lawsuits in district court in 32 counties. Every one of these lawsuits has resulted in the assessment of civil penalties. One action also resulted in a fine for contempt of court for a repeat violator. Every lawsuit has resulted in a court order prohibiting further violations and subjecting the violator to potential contempt of court sanctions if the violations were willful. Contempt of court can result in imprisonment for up to 6 months. Most have also resulted in some press coverage regarding the violations and the violator. Of the lawsuits filed thus far, 9 out of 10 have involved natural gas or hazardous liquids pipelines. We have sued excavators who simply did not call the one-call notification center and request locates prior to the excavation, who called but did not wait for the underground facilities to be located and marked within 48 hours, or who damaged an underground facility but failed to notify the operator and backfilled over the damage. Here is why we take this so seriously. One-call violations can have very real and tragic consequences, including explosion of a natural gas pipeline resulting in the death of one pipeline worker and causing another pipeline worker to lose an eye, causing severe burn injuries to an excavator and knocking out natural gas service for an entire city during repairs, causing a fire just outside an apartment building that contained a daycare center for small children, or damage to a hazardous liquids pipeline resulting in the release of thousands of gallons of gasoline near a trout stream and cleanup costs totaling more than $500,000. Unfortunately, in 2012 we had 2 more tragic examples. On April 25, an excavator failed to provide 48 hours notice of excavations to install drainage tile in rural Plymouth County. The tile plow hit and ruptured a 24-inch diameter natural gas pipeline, resulting in a massive explosion and fire, creating a large crater 100 feet long, 35 feet wide, 30 feet deep, scorching 80 acres of farmland, destroying the tile plow and bulldozer, destroying an overhead high-voltage power line, causing substantial property damage to the pipeline, and injuring 2 employees who were hospitalized. 1 week later, the same excavator conducted another excavation to install drainage tile 1/4 mile from the former site, again without providing 48 hours notice. We filed suit, and the excavator paid the maximum civil penalty for the 2 days of violation, $20,000, and agreed to a permanent injunction. On April 27, another excavator failed to provide 48 hours notice of excavations to install drainage tile, this time in rural Jackson County. The tiling equipment hit and ruptured a 16-inch diameter natural gas pipeline, resulting again in a massive explosion and fire, creating a large crater, scorching the farm fields, destroying the tiling equipment, causing substantial damage to the pipeline company. The 2 employees on site narrowly escaped injury. We filed suit, and the excavator paid the maximum civil penalty for the 1 day of violation, $10,000, and agreed to a permanent injunction. These are just a few examples of the tragic consequences that can occur when excavators fail to comply with the one-call law. We trust that most of you attending this important program are familiar with the one-call law and fully comply. Our only hope is that these brief comments will serve as a reminder to everyone of the importance of this law and the potential consequences, legal and otherwise, when the law is violated. The Attorney General's office will do its part as needed to ensure compliance. Call or be called. Thank you.